in global strategies and IP values. Thank you.
Hi, again, I'm Michael Siem. I'm not going to touch on patenting strategies. I'm not a patent prosecutor, so I'd be useless in that space. I do litigation mostly for generic pharma companies, and what I was going to talk about is something that our firm has been doing, which is non-practicing entities and patent trolls. I'm not sure if you've been following what's been going on in the States, but we represent MPHG, which has been called the most notorious troll and the most innovative patent troll. And what's been happening is there's no slides. I don't have any slides. Oh, I don't have any slides. It's okay. Okay. Thanks. So what we've been doing in this is working to monetize patents that are owned by companies, and what they've been finding is that there's been a huge backlash in the U.S. against non-practicing entities or smaller companies even that do practice but assert their patents against large groups of companies. In our case, the first situation that came up was in Vermont when we sent a bunch of letters to corporations that were using our technology that we had patented, and found that the Vermont Attorney General went after us and filed suit. We now are in the federal court there, and that likely will go up to, we think, up through the circuits and up to the Supreme Court. We also just settled a case with New York, the state of New York, as well as Minnesota, and in Nebraska, we won a motion for summary or for a permanent injunction preventing the Nebraska AG from us being able to send letters to individuals that we believe infringe. And now the ITC is actually getting involved, and there's a lawsuit that was just filed 2 days ago against them. So we're seeing that, you know, the non-practicing entities that 5 years ago, when this started, we started seeing that people were using patents in a way that hadn't been used in the past. They were using, large corporations were selling those patents to try to monetize those assets, especially those patents that they weren't using. Larger corporations, through lobbying efforts, have tried to say that the use by non-practicing entities or patent trolls is inappropriate and a violation of what the patents are all about. So what are we seeing now? We're seeing in the U.S. that Congress is trying to pass bills to make it more and more difficult to sue companies if you're a patent troll, if you're a non-practicing entity. So when you're filing complaints, you have to have detailed statements as to why your patents are infringed. So you have to have very detailed claim charts, which is very different from a typical notice pleading requirement in the United States. The second thing that we're seeing Congress doing was a recent bill that looking at fee shifting. Traditionally in the United States, what we're having is everyone pays for their own lawyers. At the end of a case, if you win, you can seek out attorneys' fees and costs, but usually those are given only in exceptional circumstances. You'll get your costs back, but for your fees, that's something that really only happens in exceptional cases. When you have a situation where you're having a detailed notice pleading that's required by the courts, this fee-shifting arrangement we don't see as really addressing any of the issues that people raise about non-practicing entities. Because if you have a detailed statement as to why your patent's valid or patent is infringed, you have a good faith basis for going forward. So the fee-shifting idea that has come up in Congress and the House, we're not expecting that to change what people are doing in this space. In relation to the Supreme Court, a couple days ago, the Supreme Court has taken a case, and that is Nautilus versus Biosig, and what they're doing is looking at the indefiniteness of a patent, and they're trying to go and restrict what kind of patents are getting allowed in the United States, and trying to make the standards for written description and indefiniteness enablement, trying to make those even more stringent so that the types of patents that they believe are being used in non-practicing entity cases are not going to be allowed to be asserted against such a large number of individuals, and there's a larger risk of invalidity. This is going to impact all practitioners if these kind of standards change, so it is something to definitely watch, especially with what the Supreme Court is doing. We're also seeing in the pharma space, which is something that I think is relatively new, are large contingency fee cases that are being brought by universities and non-practicing entities against alternative uses by the drugs. The largest one that we've seen is down in South Carolina. The Medical University in South Carolina has a number of patents. They cover the use of